Welcome everybody in the Beverly Hills Bar and other attendees out there on the Zoom. I'm Terry Maggedy, the chair of the Elder Law Committee of the Trust and Estates section. And the first thing that I do always is express our thanks to our sponsors. So we're going to review each of the sponsors here. The first sponsor is the Sanborn team and their principal, Nancy Sanborn, real estate brokers who specialize in all of our areas that we deal with, probates, conservatorships, fiduciary, sales relating to older people. They've been our sponsor for a long time. So thank you very much, Sanborn team. And for our next sponsor, I'll let Orit introduce herself.
Thank you, Terry. Hi, everyone. I'm Orit Gadish, broker and owner of Geffen Real Estate. We specialize in representing trustees, administrators, and executors in the sale of commercial and residential real estate. We're a full-service firm offering property clearouts and cleanups, as well as design and renovation, all paid through the close of escrow. We just finished cleaning up and renovating a property up north in San Leandro, and currently renovating several properties in the Southern California area. We have a designer on our team who defines a design plan and works with our general contractor on material selection and stages the property once the property has been renovated. Renovating and staging are all paid through escrow. And for the troubled assets where it's been disclosed that there are issues such as foundation issues, we have foundation contractors who provide low-cost inspections to identify the issues and offer cost-effective solutions for repair, which are also paid through escrow. Our goal is to minimize your risk and allow you to maximize the return of each sale for your clients. Enjoy your program, and back to you, Terry.
Thank you, Orit. And our next sponsor is Marcine Klein and Glen Oaks Escrow. Marcine, like the other professionals you've heard about and who are our sponsors, is an escrow company that specializes in fiduciary work, probates, conservatorships. Handles a lot of complicated escrows in that area. So thank you, Marcine, for being our sponsor. Our next sponsor is California Title Company. Again, like the others, a title company that specializes in probates, conservatorships, fiduciary, sales. Thank you very much, California Title Company. And our next sponsor, Manufacturers Bank, another provider for many people in the bar. A bank that knows the fiduciary work and what it takes to have accounts for conservatorships, probates. And so thank you very much, Manufacturers Bank, for being our sponsor. And now, right before we start our program, I'll just mention our next program, which is going to be January 24th. Speaker is going to be Randy Spira, who's spoken to our group before. Topic is going to be ethics and professional liability in the elder law space. Always something that should be of interest to our attorneys. And now I'll be introducing our speakers, who we're very fortunate to have. Both Zach Rothenberg and Miriam Mackin are with Nelson Hardiman, top-notch law firm in the healthcare space, just like a top-notch reputation. And I've had the pleasure of knowing Zach personally, actually the principal, also Harry Nelson from Nelson Hardiman, for a very long time, and have had the opportunity to work in the past with both of them on matters, and which it's been a real pleasure in the past when we've gotten to work together. And now we're going to hear both Zach and Miriam present on substance abuse providers, legal regulatory framework for them. And as with all of our programs, it's just a great area to know about, no matter which part of it you're touching. Maybe you're a trustee with beneficiaries who are having substance abuse issues, which happens all the time, or you're dealing in some other way on the provider vendor side. So no matter where you are operating in this area, our program is going to be an excellent for everybody listening. So now I'm going to sign off myself and turn the program over to Zach and Miriam.
Thanks, Terry. Really appreciate the opportunity to speak here. Can we advance to the slide, just one? Great. So I know Terry already introduced us, but just a little bit about us. We are 20 lawyers in Westwood, and all we do is represent healthcare providers and life sciences entrepreneurs. We fancy ourselves sort of a full service firm for anybody in the healthcare industry. There's a litigation practice that Miriam and I are both a part of, a regulatory team, and a sort of a traditional transactional group as well. As for me personally, I come from a litigation background. I spent a number of years doing general business litigation, and about 7 or 8 years ago, really transitioned to doing exclusively healthcare related litigation, and with a real emphasis on behavioral health and addiction in particular. It's something that feels like a cause to me. It's something that makes me feel proud to be working in. There's so much need with the opioid epidemic that's been going on for a decade now, and then amplified by the past 2 years of the pandemic. There's need beyond anything anyone can keep up with, and the folks on the front lines, the people operating these facilities, the healthcare providers are they're really heroes in my book, and it feels meaningful to me to be helping them do things the right way, stay out of trouble. A lot of them are mom and pop businesses doing this out of really a labor of love. I've realized a lot of my clients are recovering alcoholics, recovering addicts who are trying to give back and say thank you for their recovery by starting their own facilities and practices. And it really, like I said, feels meaningful to be a part of. Miriam?
Thanks, Zach. I actually, believe it or not, started on the elder abuse side when I first became an attorney, and I was doing that for about 5-6 years. And I slowly just kind of expanded. I wanted to do more regulatory work and continue with litigation, and I found myself a place at Nelson Hardeman, and I've been lucky enough to be here for about 4 years or so. Work a lot with Zach on litigation matters that introduced me into the substance abuse arena. And I agree, it's truly fulfilling work because a lot of our clients are ones that just are trying to build things from the ground up. And it's really nice to be able to help them first try to stay out of trouble with providing regulatory advice, but then to make sure that if something does happen, we're able to defend them against, the state or federal government, or against insurers that may be coming after them for money, which is quite a bit of what we're going to be talking about today.
Good. Next slide, please. So quickly through the agenda, it's a little bit ambitious. Hopefully we can get through it all. We may skip over the last bit if we run out of time. We'll spend some time on licensing and scope of practice issues, and then insurance reimbursement, the pitfalls and best practices for essentially for helping providers get paid and fend off the evil insurance companies. Behavioral health marketing, which is really a hot spot and a huge pitfall for many providers. We'll touch on some land use and NIMBYism issues, a quick legislative update on recent legislation or upcoming legislation that may affect the industry. And then, like I said, if we have time, we'll touch on the Insurance Frauds Prevention Act as well. All of these could be their own full hour presentation. We're really thinking of this as something of a survey, hitting the high notes. And please, if anyone has questions, I guess put it through the chat. And if we don't get to you, feel free to reach out by phone, by email. I'm happy to answer questions all day long if you've got them. Next slide.
Okay, so I'm going to be starting off. We're going to talk about licensing and scope of practice issues. If you can go to the next slide, please. So there's 3 levels of government requirements in the substance abuse disorder world: laws, regulations, and enforcement guidelines. We'll go through these throughout the presentation, but the key takeaways are that just like any other healthcare provider or healthcare organization, substance abuse providers, and this includes like licensed psychologists, licensed social workers, licensed LMFT, certified drug and alcohol abuse counselors, as well as treatment centers themselves, are all under the scrutiny of multiple federal and state regulatory and licensing bodies, as well as enforcement agencies. So there's always someone or something kind of hovering over, making sure that they're doing what they're supposed to be doing at all times. Now, these laws, regulations, and enforcement guidelines that substance abuse providers and treatment centers must comply with are constantly changing from year to year, and they vary significantly from state to state. Some laws that are in place here may not be in place in, let's say, Florida or Illinois or somewhere else. So it really is important to make sure that you have an attorney that practices in the state that can provide you with the information that you need to make sure that you're following the proper laws, regulations, and enforcement guidelines. Next slide, please. So there are several key regulatory questions providers and treatment centers must ask before they begin to provide any kind of treatment. These questions, and of course there are many, many, many more, help to establish an essential foundation of setting up a substance abuse treatment center. For instance, does the treatment center have the correct license or certification, or the providers, do they have the correct license or certification? Are there any providers that are under investigation by their licensing boards? Is that going to be an issue? Are your providers able to provide the services that you're offering? Is there sufficient supervision of mid-level clinicians? Is there enough documentation or a documentation program in place to make sure you're not going to have any issues with federal, state or federal or private players later down the line? Not having these key regulatory questions that you have to answer in place and making sure that you have everything set up could place the treatment center and its providers at the risk of losing their licenses and certifications. Next slide, please. So what's the difference between licenses and certifications? Just like attorneys were licensed by the state bar and can obtain certifications for specific areas of law, for instance, the Board of Legal Specialization by the California Bar certifies, appellate law, tax law, immigration, etc. The same is true for healthcare providers and those people, the other providers that work in treatment centers. So physicians and PAs are licensed by the medical board, RNs, LVNs, etc., are licensed by the Board of Registered Nursing, and those same professionals can obtain special certifications. For instance, you could become board certified by the American Board of Psychiatry, which is what a lot of our clients have. Meanwhile, treatment centers themselves, so these entities, not the professionals, but the entities, do not obtain licensures or certifications. Instead, these entities are accredited, which means that a accrediting agency, such as the Commission of Accreditation of Rehabilitation Facilities or the Joint Commission, which a lot of you may have heard of, have to come in and actually go through a very intense and stringent process of making sure that these treatment centers have certain programs in place, that the staff that they have are qualified, that they have certain programs and policies that need to be in place, etc. And there's very strict standards that they have to comply by to become accredited by, for instance, again, the Joint Commission or the Commission on Accreditation of Rehab Facilities. With that being said, there's nearly 55% of treatment centers or substance abuse facilities that are not accredited. That doesn't make them bad. There's a lot of reasons why these facilities may decide not to seek accreditation. Accreditation is costly, it's laborious for small treatment centers, like many of the mom and pop places that Zach mentioned, or the staffing and programming that they have doesn't lend themselves to being accredited. So while being accredited is great, it puts patients and their families at ease of mind that these facilities are at a certain level or abiding by a certain standard. It doesn't mean that the ones that are not accredited are not as good. Next slide, please. Another law and regulations that treatment facilities must be aware of is that in states that have the corporate practice of medicine doctrine, also called CPOM, doctors and other licensed healthcare professionals cannot practice their professions under a contract or as employees of unlicensed persons, corporations, or LLPs. In some of these states, and which California is included, the only permitted corporation form that an entity that can practice, so basically only a physician can own a personal corporation that can provide treatment. And there's rules and regulations within that about how much the physician can own, what percentage, and who can own the other. But essentially what it means is that anyone like me who is not a physician or a healthcare professional cannot just one day open up a treatment center and just hire physicians, nurses, psychiatrists, etc., as employees to provide medical services. This is because the corporate practice of medicine doctrine was designed in part to ensure that healthcare providers remain in control of healthcare decisions. You don't want someone like me that's only thinking about profit, profit, profit to come down and just say, you know, these are the treatments that we're going to provide. These are the prices that we're going to set them at. These are the clinicians that I think we should hire or fire, etc. So beyond just the laws regarding, you know, what can be set up and what providers can do, there's also important laws regarding who can actually own these facilities and what's within their scope of practice, which is, I believe, the next slide. Okay, actually, so this is a little bit more about CPOM. So not all states have corporate practice of medicine laws, and of the states that do, the rules and regulations are not identical. So again, it's really important to have an attorney in that state be able to tell you what the rules and regulations are. So for instance, I have a client right now who's being investigated by the Medical Board of California for violation of the corporate practice of medicine doctrine. In the meantime, she applied for a license in Florida, a medical license in Florida. And because her license was under investigation in California, the Florida Medical Board automatically denied her application. We were able to find an attorney in Florida that was able to help her appeal that denial on the grounds that the corporate practice of medicine laws that she's being investigated for in California do not exist, or in California do not exist in Florida. So she was able to get her license there. So that just shows you how different things are and how you have to make sure that you're complying with all the state, each state's own laws and regulations. Next slide, please. So here's the scope of practice that I was mentioning. Hand in hand with laws and regulations relating to who may own a substance abuse treatment center and who may be employed there, there's also scope of services rules that healthcare providers must comply with. For instance, just because someone is a physician doesn't mean that they are going to provide physician services at that center. That person may just be a director or a consultant. Where the lines get blurred sometimes is where individuals such as counselors or licensed therapists start to potentially provide services that are outside of the treatment center's programs or outside of their professional abilities or what they're licensed to provide. So treatment centers have to be careful that this does not occur, because just like physicians or registered nurses or whoever can be investigated for the corporate practice of medicine, treatment centers can become liable criminally for aiding and abetting the unlicensed practice of medicine if they allow this type of scope of practice issue to occur. Next slide, please. So in addition to having regulations and enforcement actions, treatment facilities also face the challenge of providing medical care at non-medical facilities. Similar to how you have to make sure that providers don't step over the line of what types of treatments or services their licenses allow them to provide, treatment centers themselves have to make sure that they're not going over the proverbial head, their own proverbial head, by engaging with patients that whose needs they can't meet. So you know, if that happens, what will happen is typically it will lead to them admitting they'll lead to overly sick patients being at their facilities, medication mismanagement, risk of overdose, suicide, and bad healthcare decisions, which all lead to the treatment center getting into trouble. So this is, I apologize. This is a serious challenge. I'm kind of looking at two screens at once here. So this is a serious challenge that treatment centers face. And they have to make sure that they really comply with what is required from them under the law, regulations, and enforcement agencies, because if they don't, not only will they get in trouble criminally, but also commercial insurers, so payers may not pay them. They may expect something that the provider, that the treatment center can't provide, and that can cause issues with income and funding. Next slide, please. And just to go back, this slide just reiterates the scope of practice. Like I mentioned before, a physician who is at a treatment center doesn't necessarily have to be providing physician services. They may be there on a non-clinical role, so assisting in establishing compliance standards and policies, monitoring compliance of professionals working on site, providing oversight of professionals in the performance of their own services, etc. Regardless, there should be a professional services agreement in place with the director. And there are terms that the treatment center and the director have to comply with, which we'll get into a little bit more later on in this presentation. But the most important is that the physician that is the medical director can't be paid on a referral basis. That will get them and the treatment center into huge trouble. But that is one of the main issues that you have to be careful with when you engage with a physician. Zach, on to you.
Great. Yeah, next slide, please. Okay, next topic here, insurance reimbursement. So I've learned that one of the key things that makes healthcare a unique industry is that in every consumer transaction, there are actually three players. You can think of it like a triangle. There's the healthcare provider providing the services. There's the patient who's receiving the services, essentially the customer. But then there's also a third-party payer. And so it's a triangle, and for a million different reasons, I think that's what mucks up the whole industry and makes it so confusing and unclear and rife with conflict. And then, of course, on top of all of that is all the government regulation that Miriam was just talking about. So there's tensions on all three sides of this triangle, and there's often sort of two teaming up against the third, and it rotates around the triangle whose allegiances are with whom. But one of the constant battlefields is the tension between the payer and the provider over reimbursement, meaning over payment for the services rendered. Next slide, please. So a little bit of context here. For a lot of years, mental health, and in particular, addiction treatment was really sort of outside the entire healthcare conversation. It was generally an all-cash business that was really siloed from the rest of healthcare. In 2008, though, with what we call the Parity Act, that started to change. Group health plans now had to treat mental health on par with or even with how they were treating physical health. There had to be similar benefits and treated the same. And then in 2010, the Affordable Care Act added to that by requiring the inclusion of mental health and addiction treatment as, quote, minimum essential coverage within any and all plans. So at this point, it sort of ignited the addiction treatment industry because there was this, by requirement, massive infusion of insurance funding into that industry. And of course, at the same time, we were also seeing the explosion of this opioid crisis. So the result was just a massive growth of addiction treatment as an industry around the country, but particularly in places like Southern California and South Florida and some of the other hotspots. They call Malibu and Orange County the Rehab Riviera, by the way. And of course, this created its own problem, which was that the insurance companies weren't used to paying this much for behavioral health. They weren't prepared for it. And suddenly they were spending a lot more money than they had ever imagined. And so they started pushing back. And thus began the war between payers and providers. Next slide, please. Now, in framing the discussion of this tension between payers and providers, there's really two general types of relationships between payers and providers. The first is the contracted provider. where a provider will have a detailed written contract with an insurance company that spells out exactly what services that provider will provide, how they'll provide it, who will provide it, what they'll be paid for providing it, etc. These are usually very aggressively negotiated by the insurance companies, and payment rates tend to be quite low. It's always a difficult decision for a healthcare provider, particularly in the addiction treatment world, to decide whether to go, they call it in-network, because the rates are generally going to be so low. But on the flip side, there is certainty because you have a written contract, and there is quote unquote steerage, meaning an insurance company incentivizes its members to stay in network. For all of you that have a PPO, for example, you know that it is much cheaper for you to stay in network. Your financial contribution will be less in terms of co-pays and co-insurance than if you go out of network. And that's because the insurance company wants you to stay in network because their in-network providers are less expensive. The other option here, of course, is a non-contracted provider out of network. And those are the folks when you're in your PPO plan who are out of your network. And with them, there's no written contract typically, and they can charge really whatever they want, but the payers don't pay whatever the providers want necessarily. There are usually different kinds of metrics to determine what the insurance company will pay for out-of-network rates, and it can be a variety of things. There's something called the usual and customary rates, which is this elusive mythical standard that somehow insurance companies have come to identify that I've never been quite clear on. Then there's percentages of billed charges, meaning for whatever you bill, we'll pay you 50% of that. Or sometimes it is based on the Medicare rates. Medicare has published rates for various services, and there may be a decision to pay 150% of Medicare or 75% of Medicare, whatever it is. Generally, when people are out of network, the benefit is they can charge more. They're generally paid more, but there's lots of uncertainty because there's no contract. And of course, there's no steerage from the payer in terms of the incentives I mentioned earlier. Next slide, please. So over the past handful of years, there's been increasing levels of conflict and tension. And I spend more than half of my time, I would say, representing behavioral health providers in some kind of disputes with insurance companies, sometimes in court, often not. And they're usually out of network providers because, of course, there's no contract. It's much less clear. There's much more room for conflict and uncertainty and dispute. And plans have come to take on sort of a quasi-regulatory or quasi-enforcement role. They have developed what are called special investigation units that go out and investigate and hunt down fraud. They're often working hand in hand with government regulators many times to seek out this fraud. I have a very cynical view of it, and I think they may also be manufacturing claims of fraud that aren't always there, but there's certainly some, and they track it down. And they have become amazingly sophisticated over time in how they identify this fraud. There is data sharing among the various insurance companies, and again with governmental law enforcement, and all sorts of very impressive data mining and mapping and pattern detection. For example, a provider maybe suddenly taking more patients from out of state, which happens a lot in the behavioral health world, might spark some interest, or a provider admitting patients coming from one particular upstream source. So an outpatient facility that gets all of its patients from one particular residential facility or hospital, I think a flag would go up. Maybe they're paying a kickback to be getting all of those referrals. Or a provider suddenly treating more and more members who have a particular plan, I know raises alarm bells that perhaps that provider is helping its potential patients to acquire new insurance so that they can bill with it, or maybe even paying the premiums for their patients so that they can bill on that policy. Next slide. So the practices that raise the risk of claims of fraud and abuse are sort of always changing. There's some that are more permanent than others, but really there's a constant evolution in the kinds of things that raise issues. In fact, I run a quarterly forum of a bunch of providers where we compare notes on who's getting hassled over which issues by which plans, so that we can all sort of respond accordingly as an industry, just to give you a sense of what we're dealing with. And so some recent ones are, like I mentioned, this procurement of policies, the idea of helping either current patients or potential patients who you'd like to admit get insurance, so that you can then use that insurance to bill claims. There are lots and lots of housing problems. So in terms of outpatient rehab in particular, there are requirements that folks spend basically all day, every day at the treatment center, doing therapy, et cetera. And they're expected to pay their own way to find an apartment. And it's a constant struggle, and it's very frustrating to me, the expectation that somebody who has been, an addict and is often in a difficult financial situation and is now supposed to spend all day in rehab, not working, can be held responsible for paying rent, finding their own apartment. So there's a lot of efforts by people who run these outpatient facilities to help their members find homes, and often to pay for them. And that is sort of a red flag as well, as it's considered an inducement, an illegal inducement. One of the constant hotspots is the waiver of patient financial responsibility. So for out-of-network members, not requiring them to pay their copays, not requiring them to pay their co-insurance, their share of the financial burden of the treatment, is something that drives the plans crazy, and that the plans hold up as being fraudulent practice as well. Charging inconsistent and different rates to different payers. And then there's the constant stream of documentation problems. And then one that's very specific to the treatment industry is the unbundling of drug testing. Most of treatment is billed on a per diem basis, 1 day of outpatient service, and then you bill the next day of outpatient service, as opposed to like a piecemeal therapy session by therapy session approach. And there's an ongoing struggle over whether the facility can also bill separately for the drug testing, the urine drug testing, to make sure people have not relapsed. So those are just some hotspots. Next slide, please. So I wanted to talk quickly about two contexts that come up a lot where providers look to an attorney. And the first one are audits. And we're seeing these more and more and more. And it is when the insurance company sends a letter, usually to the facility, and says, we're doing this routine audit. We'd like you to send records for these 30 patients, or maybe all the patients during this given time frame, or something like that. And you're supposed to send medical records and intake documents and the payment ledger, et cetera. And then the insurance company will look at it, will audit the records, maybe conduct some further investigations, have interviews with staff and with patients or former patients, and then make a determination of whether the provider is acting appropriately and within the regulatory framework. And more often than not, we'll come back with, well, here's a handful of issues that we see in your record keeping, and either just require you to fix it going forward, or else potentially seek what's called a recoupment, saying, we think this handful of services you did inadequately, or with incorrect documentation, or maybe we don't think you did them at all. We want our money back. And that happens pretty regularly, and always ends up in some kind of negotiation. And if you turn move to the next slide, please. So that's recoupment, or an overpayment is what this context is called, where they've come back and said, we want our money back. And that is often at the end of an audit, or it's sometimes sort of on its own when there's been an investigation that's happened, maybe even without your knowing it, that results in a determination by the payer that you've done something wrong and they shouldn't have had to pay you, and they want their money back. And the real rub of it is that they will typically say, until this matter is resolved, you will be quote unquote flagged and you will not be paid for any of the services that you render to our members, so that you're basically stuck having to negotiate with them. And even if you believe that these issues that the payer has identified are bogus, you're sort of stuck because they will not pay you until it is resolved to their satisfaction. So it's a difficult spot that often, not always, but often ends up in litigation. And there's a handful of arguments that you can raise. There's a statute of limitations that is, generally speaking, a year. And I've found that the insurance companies tend to forget about that and go much beyond a year. And there's some requirements that the payers have in terms of providing you with records to support their findings, and generally cooperation in negotiating in good faith. But that's just something that comes up a lot. And next slide, please.
So I'm going to be talking about behavioral health marketing, and like Zach mentioned at the beginning of the presentation, this is a huge hot topic and can land treatment centers and providers into big trouble. Please, next slide, please. So there's rules and regulations that were put into place because what treatment centers and their marketers were doing were putting vulnerable patients at risk. You may have heard the term unethical patient brokering practices. This could range from incentivizing a patient to attend a facility by paying for their travel expenses, to the most extreme end, and I'm sure you guys have probably read this in the news, but encouraging someone to relapse so they can refer that patient to a treatment facility and get a referral fee. So the main rule, it's not the only rule, but the main rule is that to protect patients, healthcare providers and organizations, which include these treatment centers, cannot pay for referrals. Zach mentioned just a couple minutes ago about the Anti-Kickback Statute, and that's landed many physicians in trouble, in jail, and has had them, have to pay hefty financial penalties. And what that is it's a federal criminal statute that prohibits the exchange or offer of exchange of anything of value in an effort to induce or to award the referral of business reimbursable by the federal healthcare programs. Similar to that federal statute, we have what's called Ekra, which is the Eliminating Kickbacks and Recovery Act of 2019, which also criminalizes paying for patient referrals or offering inducements to patients receiving addiction treatment services. It comes with 10 years punishable by imprisonment and $200,000 fine, so it's nothing to laugh at. If a treatment center is going to hire a marketer, for instance, a call center, it must provide services. The payment must be for the services provided, not for referrals. We've been involved, our firm actually drafts a lot of these contracts and make sure that whatever the contracts say provides our client with the safe harbor to make sure that there are not going to be any criminal issues, and so we comply with, there's 8 conditions that have to be met to make sure that our clients are not going to be investigated for kickback. So the one is that the agreement between the treatment center and the marketer has to be in writing. The terms of the contract have to be for at least 1 year. The agreement must specify aggregate payment and when that payment is supposed to be provided. Payment or compensation must be for fair market value, and it has to be determined with an arm's length negotiation. The agreement must set forth the exact services that the marketer is being required to perform. Compensation must not be determined in a manner that takes into account, like I mentioned, referrals or return on investment. All arrangements must be in that one contract. There can't be multiple overlapping contracts, so everything has to be in that one contract. And the arrangement must serve a commercially reasonable business purpose, which again goes back to the referrals. So we've many times, put a completely compliant contract into place, only to have then our clients that have like a verbal discussion with the marketer or call center, whoever, where they talk about what, how many patients they expect to receive or return on investment, which completely negates the safe harbor that the contract provides. We've also had clients come to us with contracts that they've already signed into that do not satisfy all 8 conditions. And these are not small contracts. Typically, you know, they range from like $30,000 a month to $100,000 a month that these treatment centers are paying for marketing. And what happens is that these marketing, you know, call centers or whoever provide very good services the first, you know, 3-4 months, and then after that, you know, there's nothing. The client gets nothing, and they come to us and they want to either, you know, file a lawsuit against the marketing company, or they want to, you know, get their money back, and they're in a really tough position because the contract that they entered into is not compliant in and of itself, and so that would cause our clients to get into trouble. In the slide, I also mentioned like marketing personal classifications, which depends on IRS criteria and cannot be based, you know, on anything else. What I wanted to mention specifically about this is bonuses. Going back to Ekra, there are issues about, you know, what kind of bonuses, or if bonuses are even allowed for employees that kind of do this marketing. Now, Ekra, I believe, does not allow bonuses, but I know there's some, you know, there's some disagreement with that. Basically, what is in the contract or what you're going to be paying someone should be in writing, and you should not sway or, you know, diverge from that at all to make sure that you're compliant with the safe harbors and not going to be, you know, investigated for any kind of referral scheme. Next slide, please. So to bring in potential patients, many treatment centers either advertise on their own or they contract with, you know, call centers or something similar, so that the call centers can advertise for them. The same rules and regulations apply to these call centers. Referrals are strictly illegal, so they can't try to engage you in that either. Paying for the volume of call center or marketing services utilized at a commercial reasonable price is okay, but you have to, again, make sure that the contract that you have in place is in writing and that all 8 conditions that we previously discussed are in place before there's any exchange of money for advertising. There's sometimes questions about whether there's a lead is different to a referral. It really just depends on the facts, but 9 out of 10 times, you know, there may not really be much of a difference, and you don't want to be left in a position where you have to defend yourself, particularly as, you know, the rules don't, it doesn't matter whether you knew or intentionally engaged in illegal referral practice. If it happened, it happened, and you'll be, you know, you'll be liable for the consequences. Next slide, please. So clinicians and call centers is admissions about sales or helping people. It's, in reality, it's neither. When a patient calls a call center, or if they're calling a treatment center that is advertising for themselves, the person that's taking the call has to be careful to only gather the information that's necessary to establish what that patient needs or what kind of treatment centers are available to that patient. This is oftentimes because the person who's taking the call is themselves like a therapist or a licensed professional. And if they're asking too many questions or engaging too much with the potential patient, that could be considered a consultation or assessment. And you want to make sure that you don't cross that line when a patient or an individual calls to find out what treatment centers are available to them. Slide, please. So going back to a couple slides ago and what Zach mentioned, illegal kickbacks are not limited to referrals. He mentioned, for instance, you know, patients that need to, you know, rent a room or rent a place while they're in treatment, and the treatment center is trying to help the patient with that. The same is true, for instance, in, you know, bed vouchers. It's kind of the same situation. Marketing companies and treatment centers have been very creative in the past about these kinds of arrangements and trying to get past the obvious like referral setup. But any kind of quid pro quo arrangement is a problem. For instance, one that's mentioned in the slide is an arrangement where a sober living home sets up a pay for bed vouchers on behalf of the client so that they can keep that client in that location, which is obviously not allowed. The key thing to remember is that if it looks like a referral, smells like a referral, or sounds like a referral or anything similar to that, something where you think that you're giving something to keep that patient or get that patient, just don't do it. It's important to make sure that you kind of stay within the boundaries of what you're allowed to do. We've been asked in the past whether written contracts to rent beds on a commercially reasonable terms, which are not affected by referral value or volume, are permissible. And they may likely be permissible, but we would have to know the terms of the agreement to make sure. So again, don't attempt to sway outside what it is that you're trying to do, and make sure that you're complying with all the rules and regulations so that you don't get into trouble. Next slide, please. So again, Zach mentioned procuring. Insurance companies obviously have a stake in what's going on, and in addition to what Zach mentioned about what these insurance companies do to investigate, other examples are they check to see whether a patient's address on their new application is consistent with their previous address. They check to see whether the address is linked to a sober living home or a treatment center. They check to see who is paying for the policy, whether it's the individual themselves or someone close to them that's paying for it. And if it's not, if it's, for instance, the treatment center that's paying for it, obviously that's an issue. They also look to see how long the policy is for. If it's something that's in place for a short period of time, again, that can raise red flags. And as if there wasn't already enough laws and regulations to get a treatment center into trouble, there's another California Penal Code 549, which makes it a criminal offense to solicit, accept, or refer business to or from any person or entity with the knowledge that that individual will submit a fraudulent insurance claim. On to you, Zach.
Great. The next slide, please. So in the interest of time, we're gonna zip through this. I want to make sure to save a few minutes for Miriam's legislative review. So one of the other hot topics here has to do with land use. As there was this explosion of addiction treatment, folks started moving into the community and popping up more and more in the neighborhood are sober living homes or small residential treatment facilities, et cetera, which has obviously caused tension in the community. So a little historical context first. Next slide, please. So up until the late 1970s, people with mental illness, including those with substance use disorders, were often sent to institutions, these large siloed institutions outside of the community. But the clinical views changed in the 70s, and it was determined that it was actually better for folks to get into the community, interact with people a little more, and not be segregated from the rest of the world. And a meaningful case in 1977 was Moore versus East Cleveland, which went a long way to redefining what was thought of as a family unit, or a single housekeeping unit is another term of art, so that we're not just thinking of a mother and a father and children, but it could be any other relatively small group of people who are acting as a single housekeeping unit. And that enabled group homes and treatment facilities and things of that, like halfway houses, quote unquote, to move into the community, into zones, places that were zoned residential. And that really started the floodgates in the 2000s and the 2010s with the Parity Act and the ACA. As I mentioned, more sober living homes and residential treatment facilities were moving into the community, causing some tension, as you can imagine. And this created sort of a major battle line in land use that has really defined behavioral health. Next slide, please. So when we think of the protections that these treatment facilities or folks with addiction are using to protect their rights, there are federal protections, there are state protections. We're going to start quickly with the federal protections: the 14th Amendment, the Fair Housing Act, the ADA, and then the Rehabilitation Act. Next slide, please. So the Equal Protection Clause of the 14th Amendment requires a legitimate state interest before similarly situated groups of people can be treated differently. In the case of Moore versus East Cleveland, again, was pivotal, as was the city of Cleburne, in determining essentially that there is no sufficient state interest in, for example, the protection of neighborhood property values, or a concern about increased financial or administrative burdens of having group homes in the community. Parking and traffic, more law enforcement, things like that are not a sufficient basis to exclude similarly situated groups of people from a residential zone. Next slide. The Fair Housing Act, the FHA, identifies all sorts of protected classes and prohibits special requirements in land use, among others, from restricting those classes from having the freedom to choose where they live. Folks typically think of things like restrictive covenants based on race, or special use permits for certain religious institutions or things like that as things that were the target of the Fair Housing Act. But also in 1988, there was an amendment to the FHA which identified persons in recovery as a protected group. In the case of US versus the Borough of Audubon was an important case. It was a small residential facility, and it was determined that it must be treated like a quote unquote traditional family under the FHA. Next slide, please. The Americans with Disabilities Act is frankly quite similar. I won't spend a lot of time. Title II prohibits governments from discriminating in zoning decisions. Alcoholism and drug addiction are disabilities under the ADA. Next slide. Now, in many of these protections, there are three different kinds of analyses. You probably all remember these from law school. I'm no constitutional scholar, so I won't dive into it particularly, other than just to say that they are the disparate treatment, which often looks at discrimination on its face, a facially discriminatory housing ordinance, for example, one that defines residential use to mean a blood-related family, for example. Or there's disparate impact, which may be facially neutral, but has a discriminatory effect. So an example, again, would be the definition of a single-family unit that requires 2 adults or fewer. It doesn't say they have to be blood-related or anything like that, but the outcome is going to be traditional families, okay, residential treatment facility with 6 adults, typically not okay, and that would have a discriminatory impact. And of course, failure to make a reasonable accommodation. Local governments have an affirmative duty to provide reasonable accommodation regarding housing and, for example, disabled people. Next slide. State protections, again, the California Constitution, FEHA, and then a handful of statutes that I'll touch on very, very briefly. So next slide, please. The California constitutional protections as they relate to this industry tend to focus on privacy. It's slightly different prism for looking at the issue than the federal constitution. And the concept is generally, as expressed through Santa Barbara v. Adamson, that you have the right to be left alone in your own home and essentially the right to choose with whom to live. So again, same outcome, same result, slightly different prism of how to look at it. Next slide. So FEHA, I'm not going to get into. It is essentially the protections of FEHA are essentially treated the same as the ADA and the FHA. Next slide. I want to talk about a couple of state statutes, and 2 of them are under the government code. 65008 extends protections to the building, development, and financing of new residences. So it doesn't just focus strictly on zoning, but also on building. And likewise, 65583 A5 affirmatively requires local governments to include in their housing element an analysis of real or potential constraints on housing for the disabled. So essentially they have an affirmative duty to make sure there is sufficient housing for the disabled. And lastly, next slide, please. 11834.23 is really the one that I spend the most time focusing on, and it's a really big one for this industry. And it states very clearly in black and white that that treatment facilities with 6 or fewer people must be considered a residential use for all purposes. So it takes all of the case law that followed the FHA and the ADA and really codified it in a very clear way and says, look, 6 or fewer, treatment or recovery facility, it's a family for all purposes. And that's great if you fit the definition. The problem is if you're 7 beds, you do not get the protection of this statute. And there is an ongoing dispute over whether this statute protects sober living homes, which do not provide treatment by definition, cannot provide treatment by definition, and whether they are protected under this statute as well. And that's something that really hasn't yet been tested. I think the answer is you're probably not protected, but because there is no conceivable rationale for distinguishing between the two, at least in my view, I think that's something that will change over time. And it looks like we have a couple of quick minutes. Miriam, if you want to hit the high notes on the legislative update.
I will do. Okay, can you go to the next slide and the slide after that, please? So there's several promising bills. One is AB 666, which is intended to spur the training of 1,000 new counselors to treat addiction treatment. Just as a kind of a frame of reference, there is roughly 2.7 million residents who meet the criteria for substance addiction in California, but we have fewer than 20,000 accredited counselors to serve those residents. So this would be a huge step for California. And what this bill does is basically it funds the tuition assistance, waivers for testing, and it basically ensures that there was going to be a lot more counselors to treat patients that we know we have in California, but are not coming forward because there's no one or nowhere available to them. Then in September of this year, Governor Newsom signed into law AB 541, which helps patients in drug treatment programs quit smoking. What they found was that there's a disproportionately high number of smokers among California residents in drug treatment programs. And so what this law does now, it helps treatment centers support patients that have a reliance on tobacco. And it helps to make sure that there's no relapse, that there's immediate health benefits that will help also then in the treatment programs themselves. What it does for the treatment program, and there is one little caveat: if the treatment program that the patient is in cannot support that patient that needs like tobacco, help with quitting smoking or some kind of tobacco treatment, they actually have to refer that patient out, so they can't keep that patient. But if they're lucky enough to be able to keep that patient, these treatment programs are now actually able to bill for something more. So it's another source of revenue for these programs. Next page, please. So this is kind of I'll go through this very quickly. Zach mentioned something before about a cycle, and this is basically what to show is going on all the time in healthcare. There's always a huge need for something, like for right now, there's addiction treatment, mental health issues, suicide prevention, etc. And all of a sudden, there's a need, so all these treatment centers or providers come out of nowhere. Then there's all this billing that's being submitted to Medicare, Medi-Cal, the private insurers, and then they're wondering why there's so many bills, why there's this flood of new claims, and then they go back and try to regulate everything. And this is kind of what happens, and it's something that we've seen very often and are recently seeing with like Ekra prosecutions where treatment centers are being targeted for stuff that they were initially there was no regulation for, but that there was laws put into place to help to make sure that people that need addiction treatment received it. So we can talk about that if you guys have any questions, but go on to the next slide, please. Another promising bill is AB 1158, which touches on what Zach mentioned before about the 6-bed residence. There's always that 6-bed marker. And this bill basically requires that the facility, if it has 6 beds or more, that there's specific insurance coverage. And if there's less than 6 beds, that the facility only has like a general liability insurance coverage. Basically, what was happening was that there's these big treatment centers or facilities that are very underinsured. Basically, they just have renter's insurance, and it was putting a lot of pressure and liability on patients and the facilities themselves. And then SB 349, basically the title says exactly what it is: California Ethical Treatment of Persons with Addiction Act. It's basically to make sure that there's more regulations in place against again, with marketing and advertising so that, you don't dupe a patient into coming to your facility when you don't have the means to care for them. It also ensures that these treatment centers provide the patient with a bill of rights, which is something that we see all the time in hospitals, to make sure that the patient understands what their rights are, and if they don't get what they deserve, that they can seek restitution from the facility. It basically puts more pressure on the facility to provide ethical care to the patient. Next slide, please. There is a bill up north in Sacramento called AB 1542, which is the Yola County Secured Residential Treatment Program. And what it does is it uses a Texas model where it juxtaposes incarceration and treatment in one. And this is a huge problem because it's blurring the line between medical care and punishment. And there's been a lot of criticism about it. And one thing is that it's likely, other than the fact that it's a huge issue as far as treatment, it also means that it's likely that the treatment providers will be coming outside of California, and it's not going to be, it's not going to help providers within the state. Slide, please. AB 77, it's a substance use disorder services bill that won't go into effect until 2026, so we have a long time till then, but it basically puts a lot more, it gives the California Department of Healthcare Services authority to do certain things, put regulations into place, do on-site inspections, etc., and to revoke a license if the facility is not doing what they're supposed to be doing. And the last slide, please. California has put a huge surge of money into mental health and addiction treatment, and for 2022, there's been two notable programs that have received a lot of funding. That's the Behavioral Health Continuum Infrastructure Program and the Children and Youth Behavioral Health Initiative. It just, you can see the numbers on the slide. There is a lot of money being pumped into making sure that people are getting the services that they require. And we're a little bit over the schedule, so thank you so much, everyone, for attending. Zach will have the last say.
Only to say that I'm sorry we run out of time. If you have any questions, again, feel free to reach out to either Miriam or myself, and we're happy to talk about this stuff. It's a real passion for us, so don't feel like you're burdening us with your questions. We love it.
I mean, Zach, there are two. There are two questions right there. If you want to take a few minutes, if you see those two, and if you think they can be, addressed pretty quickly, you could feel free. Which California?
They should have us contact us because those are
they're
very intricate. Yeah.
Okay, that's as expected. Anyway, Miriam, Zach, thank you. So interesting. And we, on the chat too, somebody said, great presentation. I really appreciate you guys being here, and hopefully sometime in the future, we'll have you back after this, as the whole industry evolves. So thank you. Thank you, everybody in the webcast audience. See you at our next talk.
Thank you very much for having us.